another question along the same lines. What about if we've got like a second partner or a de facto partner who may have children before, so that your child has a partner and inherits some stepchildren. So you would like to not see if your child passes away before their partner, that the money doesn't effectively go into the stepchildren's hands. Is how would we deal with that?
Yeah, that's probably I think since I started my own business, it's been almost 2 years now, I would say that probably 70 or 80% of my clients are blended families, and that's the second relationship, children from different relationships, and there's no question they are difficult. They are complicated, and it can be very difficult to balance those rights. What the court cases say is that your primary obligation is to your spouse, and that doesn't matter whether it's a second spouse. Your primary obligation is to your spouse, and the leading cases say you should make sure they've got a roof over their head, enough income to continue living in their current fashion, and a fund for contingencies. So how do you balance that with the fact that you've got children who you want to make sure of receiving the fruits of your wealth, of your work? There are different things you can do. There's a thing called a life interest, so you can, in your will, again, these are trust structures that you can build into a will. You can effectively allow your current spouse to live in the house for as long as they need to, if the house is in your name. If they're living in the house, then you would generally want to make, well, I don't say generally, I would only ever recommend leaving what's called a portable life estate, because there are circumstances, particularly with a lot of the blended families I'm seeing are older people who have remarried, the twilight relationship it's called. If you've left the life interest to your spouse and it doesn't allow them to, for instance, move into a nursing home or to cover the costs of moving into a nursing home or to downsize, you can almost bet that there's going to be a problem later on. And so I'm generally always advising to effectively leave a trust or a fund which includes the principal place of residence that provides for the spouse's accommodation needs for the rest of their life. The way that actually works is that if your children, for instance, are your executors, the house goes into the name of the executors, and they just hold that property on trust subject to the right to reside. The advantage of that is then when the person passes away, the house effectively forms part of the estate again, and the children get it or their children get it. So that's one tool. Another tool that I use is called a contract for mutual wills. And a contract for mutual wills is again, none of these things perfect, but I think it goes some way, particularly in the blended family. And what that effectively is particularly if you've had a long second relationship and you've effectively accumulated your wealth together despite the fact that there were children from a previous relationship, people will leave their whole estate to the spouse, and then they'll both agree as to how they want their estate to go when both of them have gone. So that may be 50% to my kids and 50% to your kids, or whatever they agree is a fair resolution. And then you effectively have a contract whereby both of you agree that you won't change your will if one of you has passed away. You won't dispose of the assets for the purpose of disinheriting the first of you to pass away's assets. So again, it's not a perfect tool because over time, like a prenuptial agreement or those sorts of things, these things lose their validity or lose their strength over time because circumstances change. The thing that a contract for mutual wills does is it provides stepchildren with an additional ability to make a claim against the step-parent if they wouldn't otherwise have a claim under family provision. So as I said earlier, particularly if you've got adult children and you then meet your second spouse, the children wouldn't be eligible in respect of the spouse's estate. But if there's a contract for mutual wills in place, then they have a cause of action to be able to pursue the second spouse if they, after the death of the parent, go and change their will or go and, start giving assets away, that sort of thing. So I'd say it's a really complicated area. It's very, very common these days, and it takes a good deal of work. One of the things about the work that I do is that I probably talk too much. I spend a lot of time with my clients, sometimes up to 2 hours, but for an estate planning session. But I think it's important because you've really got to understand these issues and understand everything that goes into it. So, it's important to get really good advice in those circumstances. And it is far from simple. Every single case is different, and you need to know